Hi, thanks for being with us at this latest podcast from the Touro Law Review. My name is Michelle Zacharin. I am a professor. I teach legal process at Touro, which is the first year legal research and writing class. And I really love working with the Law Review, and I love being part of these podcasts. Today, we are interviewing and meeting with someone who recently published in the Touro Law Review. His name is Edward J. Curtis, and he has been an assistant attorney general in New York in the Litigations Bureau and in the Claims Bureau, and is currently retired from that service. But really exciting, he is a Touro Law School graduate and also served as the managing editor of the Touro Law Review. So with that, I'd like to introduce Edward J. Curtis and let him start by giving a little bit more about his background and a little bit about what we will be speaking about today about his publication.
Okay, good afternoon. I graduated from Touro Law School in 1987. From there, I went to the Supreme Court of the State of New York Appellate Division, Second Department. I was there for about 2.5 years. I worked at I went from there to the New York State Attorney General's office in the Litigation Bureau and worked there for a total of about 25 years, perhaps a little longer. Except for a period during the late 1990s where I worked at MFY Legal Services in the Mental Health Law Project. And a lot of my experience has been in the context of mental health law and mental hygiene law. In particular, I was responsible for defending the constitutionality of several statutes, including the Kendra's Law, which established assisted outpatient treatment in New York State, Governor Pataki's Sexually Violent Predator Initiative, and the Sex Offender Management and Treatment Act. And basically, in the course, well, you know, as one of these little side things that happen in your life, I live in New York City, and I had obtained a handgun license in New York City. I was interested in the Second Amendment, but like most of us, I think it's a really arcane area of the law, and there's many of us don't really understand it very well. I was trying to understand the law, and I had read the Supreme Court's decision in United States versus Miller, which was in 1939. And following probably the advice of my legal methods professor, Eileen Kaufman, I had tracked back through Miller to the case that Miller had cited, which was Imet versus Tennessee. It's an 1840 case from the state of Tennessee. And I found that that particular case to be particularly interesting. It was the only case that Miller cited in support of its proposition concerning what it described as ordinary military equipment. So that was a background, and that's how I got interested in the article.
No, that's great. Thank you for that, and I thank you for starting us off with that. And it's wonderful how you bring this back to your legal writing class, and one of our most wonderful professors ever in the school, Eileen Kaufman. So that's great. So I love to hear that it brings you back, and that's what had you started to keep reading and to read some of the cases cited within the case you were reading. That is a great way of doing research, and that is exactly what we try to teach. So the Imet case that you speak of is from 1840, right? So the fact that this 1939 case that was relying on a case from 1840 as the only case that it was using as support, yeah, I mean, that's all that you had. That's all you had to work with. What was it that they were using from this Imet case that seemed to stand out as something worth support for the proposition? in that case, in the Miller case?
Well, I met, as a Miller is an 80-year-old case, and I met is 100 years before that. And really, there is not a great deal of case law on the Second Amendment or what that explains what the basis is. As you know, the Second Amendment states something to the effect of a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. In 1840, the militia was still something that was used for the country's security. The militia is really a group of all the able-bodied citizens, the male citizens at that time, but of course, nowadays it could be anyone, who could be called upon to defend the state. And this was kind of a construct that was used more in the early days of the country. During the English Civil War, the militia would be called out to defend their towns, really. When the English and other people emigrated to the United States, militias were little organizations in towns that would defend against attacks, in some cases, mainly attacks involving Indian tribes, really. And honestly, the militia itself was not a very, it didn't perform so well. Nevertheless, it was relatively inexpensive as opposed to having a regular standing army. So this was an important thing for the local governments to have, something that was going to create security for them. And the governments would periodically muster their militias, have the people come out and drill with weapons. And this is the point of I-MET. In the case of I-MET, the state of Tennessee had essentially banned concealed weapons. These were, and in the particular case of I-MET, this man I met was going around town. He had a Bowie knife concealed under his clothes, and he was searching for this other man, apparently in the hope that he would encounter him and take revenge on him for some slight. Tennessee at the time prevented people from carrying concealed weapons. The government, so I-MET was taken into custody, and he argued that the case against him should be dismissed because he had a right under Tennessee's version of the Second Amendment to bear arms, such as this knife. The I-MET court rejected that. They upheld the state's concealed weapons statute. And their reasoning was that the purpose of the Tennessee statute was not infringing on the people's right to keep and bear arms for the purposes of the militia. The arms that were protected by the Tennessee Amendment were military arms. And military arms are not things that you keep concealed. When you are defending your state or your town, or you are trying to forestall some sort of insurrection or invasion, you don't do it with something that you keep hidden under your clothes. You do it with rifles and, well, generally rifles if you're talking about individual soldiers. And the IMET court ruled that weapons that are not kept or born openly and obviously were not protected under the Second Amendment. It was only those weapons that were going to be used for military purposes. For example, in 1840, you would not show up to a militia muster with a Derringer that you have in a pocket. That would do you no good. And that's exactly what the IMET court stated. It said that weapons that are used for personal broils, things that are only useful for robbers and assassins are not the kind of weapons that are protected. They are not what the IMET court called ordinary military equipment used for the common defense.
So that makes much more sense I think to anyone who doesn't really know a lot about the history of the Second Amendment, just to hear that it was really based on the need for a militia at that time. And that distinction that was drawn, even though it was in 1840, it was many years ago, that distinction is very clear, that a concealed knife is not one that was looking to be protected under the Second Amendment, because that isn't something that would have been used if you were going as part of the militia. That is something that would be used more for nefarious purposes. And that's not what the Second Amendment was looking to protect. And that gives a lot of insight to people who may not otherwise know. When we hear the right to bear arms, it's easy to hear it on a general level. Well, that must mean all arms. That must mean any kind of arms. But when you really think about the courts going through the analysis, it does help us understand what the context was back when it was written. And I think that's really important. So when you say ordinary military equipment, I know you write about how that can be defined. Do you want to just give a quick summary about that so that it's clear of how do the courts define ordinary military equipment?
Yes, but one thing I'd like to bring up first, Professor, you've done legal research. You know that sometimes when you're looking at cases that are 80 years old, 100 years old, they're often kind of difficult to pull up on the legal databases like Lexis or Westlaw. However, it turns out that a lot of these cases, including IMET, are regularly available through a normal online search, either using Google or something else, because a lot of the Second Amendment, I guess the people that are promoting this as their current, I guess, whatever their position is, have put these cases online. IMET is actually available through an online search at several different websites. So it's not as though it would be hard to find or hard to read for yourself if you're interested. It took me a while to get it because I started off as looking on Lexis or Westlaw, and some of those cases are pretty old, but IMET is really readily available. The other thing that I should bring up about IMET, which I don't think will come up otherwise, is it did distinguish a case from Kentucky, which was Bliss versus Commonwealth. And in the Bliss versus Commonwealth case, which is another case that's available through a simple online search, you can, the Kentucky Supreme Court, in a situation similar to the case of the defendant that I met, found that Kentucky's amendment did protect the criminal defendant there. However, in Bliss, The constitutional amendment in Kentucky specifically gave protection to people who carried weapons for their own self-protection, as opposed to the situation in Tennessee, as opposed to also the situation in the Second Amendment. The Second Amendment does not refer to self-protection. So that's kind of that was kind of an interesting point.
I don't
Yes.
mean to interrupt. I'm just curious about that. So the right to bear arms for self-protection isn't really from the Second Amendment, but it has been interpreted that way, at least in the Bliss v. Commonwealth case. But that was a Kentucky Supreme Court case, you said. So
It was, but it was.
Yes, sorry. Thank you.
It was based on an amendment that specifically provided that people in Kentucky could carry weapons for self-protection. And the Second Amendment and the Tennessee Amendment did not provide that. So earlier you were asking me about how these military weapons were defined. So ordinary military equipment is, it does not include all useful military equipment, as Justice Scalia pointed out in Heller. Ordinary military equipment at the time of the Miller decision did not include the weapons that were prescribed or limited really by the 1934 Firearms Act. And those weapons were, among other things, machine guns, short-barreled rifles, and short-barreled shotguns. The criminal defendants in Miller were found in possession of short-barreled shotguns. And the district court had dismissed the action against them, finding that the National Firearms Act of 1934 violated the Second Amendment. The Supreme Court reversed that, said and stated that it could not find on the record, and it was a simple, as you can imagine, it was not a very detailed record. You basically had the criminal charges, and then you had the Firearms Act. So there was a motion to dismiss. The Supreme Court found on that record that it could not take judicial notice that short-barreled shotguns were ordinary military equipment. Now, going up to Heller in 2008, Justice Scalia noted or referred to Miller and basically endorsed the position that the Supreme Court took in Miller. But he also said that it may seem to people that all you need to do is show that a weapon has some military use. And that, in fact, is not what is protected. It's only ordinary military equipment. It is not all useful military equipment. Obviously, in 1939, as Justice Heller or Justice Scalia pointed out, machine guns were useful in as military equipment, but they were not the kind of ordinary military equipment that a typical citizen would have in their possession and that would contribute to the common defense. Generally, a typical citizen is going to have weapons that are not, well, they're not going to be unusually dangerous. Obviously, like machine guns, explosives, things like that. They're usually going to have rifles. And in Heller, the Supreme Court said that the government could not ban an entire class of firearms. And in that case, the question was whether handguns could be banned. And the Supreme Court ruled that they could not not in general anyway. So while there's some ways that they can be limited, which I'll try to reach in if I can. I see that I've actually been talking for a while. While there are ways to limit those weapons, they can't ban an entire class of them. Does that answer your question?
Absolutely. No, that actually made it very clear. So I think the distinction between useful and ordinarily used in the course is important for us to think about. And that was very helpful. So there are a few things I think everyone would like to know. First of all, you do talk a little bit about the First Circuit case, the cases from the First Circuit. And I know it's a little confusing because the name is cases, but it's also a case. But I do think you should maybe just touch on that and why that's important. And also eventually I'd just love to hear, and I don't want to keep you too long, but we appreciate you being here, but I'd love to hear just any recommendations you might have for the future that, what can we do? What can we do? So yeah, go ahead and we can take it from there.
Okay. Well, just to briefly cover the cases decision of the First Circuit. The cases decision came down in 1942. The First Circuit considered the Miller decision. As I said, it was a rather limited decision, and they found that they criticized it as already outdated. And their position was that in what they called commando units, some sort of military use could be found for almost any weapon. And what I said in my article was that there are several problems with this. To begin with, when you're talking about commando units, you're actually talking about elite soldiers. They're not even regular soldiers. They have a higher degree of training, experience, and conditioning than even regular soldiers have. The fact that some use can be found for almost any weapon does not make those weapons ordinary military equipment for the purpose of the militia. Like I said, a Derringer would not be something that you would bring to a militia muster. You need ordinary equipment, ordinary rifles and equipment like that. These kind of special weapons that a special military organization that's subject to training, discipline, and conditioning would have, it's not a good comparison. Subsequently, several of the circuit courts of appeal kind of adopted the collective rights argument. That is that the Second Amendment was a collective right rather than an individual right. It's not a very strong argument because all the other rights are individual, so it's a little hard to see why the Second Amendment would be collective rather than individual. And eventually Heller rejected that position. So as far as going forward in the future, one thing that normally what you can expect in regulating a militia would be, you would have to take into account the kind of citizens that would comprise the militia. These would be mostly people with no military training, not much military discipline. And unfortunately, this is the reason that the militia was not very effective. They fell down on the job of doing simple military tasks like setting sentries, and a lot of militia forces were destroyed because they didn't do the simplest military operations. So although you need, the militia will need like some sort of lethal equipment. They don't necessarily need the sort of semi-automatic rifles and semi-automatic handguns that might be that the regular military with their training and discipline could use. These would be, there's a chance that a militia equipped with that sort of weaponry would be would waste ammunition. They might endanger each other. And I thought that it'd be fairly easy to make legislative findings that that would encourage the militia members to use manual action weapons, bolt action weapons, for example, action rifles, and perhaps revolvers that would be easier to use, easier to maintain. There would be less chance that people would be wasting ammunition. All of these are kind of military considerations that the legislature could use. The courts normally defer to legislative findings about legislation, but it's those kind of that kind of deference is particularly pronounced in the area of military decisions. In my article, I referred to the Gilligan v. Morgan case, which was a 1972 case in which the injunctive relief was being sought against the Ohio National Guard following the Kent State shooting. And the Supreme Court ruled that challenges to the training, equipment, and weaponry of the Ohio National Guard were not a justiciable issue for the federal courts. So I think that there are certainly methods through which state legislatures can regulate the kind of weapons that militia members are supposed to provide for their service.
Yeah, so
Does that
that's
help,
a,
or-
yeah, very much. That's a good suggestion. And who knows, right? Who knows what will happen? It's the legislature is always changing. We never really know, but that's a great suggestion. And I just want to say one more time, this article was really great to read and great to get information, a background on this area. Like I said, that I personally didn't have a lot of knowledge about, and I bet there are others out there who don't. But you wrote it so nicely, so it was more of a teaching tool, more of an educational tool, which was so great. And this corresponding conversation with you really does help explain it and bring it to light. So we thank you for being here. We thank you for writing and also for having the conversation with us today. It's a pleasure meeting you. And thank you so much for everything. We wish you well. And we hope everyone, we're going to publicize this. We hope everyone does take the opportunity to take some time and read through it.
Okay, well, thank you very much. Thank you very much for the interview. Thank you for publishing the article. And I hope that it's going to be a useful contribution to the legal scholarship. Thank you, Professor.